was an attempt to try to protect whatever the Philippines had against these overwhelming international forces. Might not have been successful in the end because we eventually did agree, come to an agreement, we acceded to the demands of the international community. But that should not be the end of it. Because when we comply with these international obligations, does that mean that we have already basically accepted that there's nothing we can do to protect our national interests? That we just give everything up, anyway we agree to it? Is that the kind of attitude that you now take? Which for me is more in keeping with the Manglapus doctrine or FOPA. You remember at one point, Manglapus said, well, if you're going to get raped, you might as well sit back and enjoy it. Is that now the policy? That is my problem when I think about this kind of perspective. The formalistic perspective in international law, which is also very perpetrated in our legal education. This is probably the one for the lawyers. Those of us who go through the legal education system here, number one, has it ever really been emphasized to a lawyer, law student, that international law works in a very different way and uses a very different framework from domestic law? For one thing, we are a civil law country, but if you look at international law, its development has been driven mainly by common law. Common law countries, common law principles. There's very distinct difference between these two systems. Okay. If you remember, for example, the controversy over RA 9522, you had people like, well, senators saying, oh, we should just draw our lines, file our claim, and send it to the UN, or we should just go to the UN and have them adjudicated. That is completely uninformed perspective because it doesn't work that way. International law simply doesn't work that way. But what you can see from those kinds of statements is that they conceive of international or understand international as if it were national law, as if there's a register of deeds, as if there's a regional trial court, or as if there's some kind of judge or police that the country can go to because there's a problem. But there is none. That's the thing. That's what most people don't understand. It doesn't work that way. And now we have litigation, again with respect to the people who do use litigation here, we have litigation becoming one of the key tools for deciding national issues. In this particular instance, national interest being decided by litigation, which is the worst possible tool you can use because litigation basically have two contending viewpoints and a judge, very adversarial process. One party wins, the other loses. That is not really the way for you to decide a matter of national interest where it's not a winner-take-all situation and where there should be room for compromises and shades of gray. Hindi yun black and white. If you look at these drawings, the black and white is when you say, okay, this area is allocated only for the international community. But and then you don't consider the impact on municipal waters, the impact of biodiversity science, etc. Everything falls by the wayside because this is our priority. This is basically the priority that is established by law. This is the priority use of this area is for military vessels of foreign powers. If there's a problem in the implementation, well, they should not be there at all in the first place because vessels have priority. Okay. And that's not the way to do it, really. Same way, 9522. Or if the challenge of constitutionality goes against, is then turned against whatever the bills turn out to be, no? Whatever these new bills turn out to be, you're going to have our national maritime boundaries decided not by a conscious act of the executive or the legislature, but rather by the judiciary, who may or may not have considered all of the future impacts of that kind of decision. Case in point, some years ago, Scarborough Shoal, which we are saying is our territory, no, was ruled by the regional trial court as not being part of the Philippines, which goes against all of the declarations of the executive. And now it's has basically been amended, or not amended, superseded by 9522. Because now 9522 says that Scarborough Shoal is part of Philippine territory. And yet you have that kind of a decision made by a judge. And the worst thing about it was that he was saying that there is an exclusive economic zone boundary between Scarborough Shoal and the Philippines. That boundary is of Zambales. So between Zambales and the Treaty of Paris Line box that you saw earlier, there is an exclusive economic zone boundary, meaning everything beyond it is not ours. And you have that kind of decision coming from a judge. That is why litigation is not the tool to decide these issues. Which is why I cringe whenever I see this being raised. Second. Now, the other problem is that actually the national interests seem to be very undefined. Has anyone here seen a white paper on the national interest? Like in the United States or China or Canada or whatever other countries, you will find literature defining or at least explaining what the national interest is, especially with respect to issues, which gives the people a reference point to understand government's actions, government's motives, government's objectives. Here we don't have that, fortunately. We had a paper some time ago, maybe in the 1990s under President Ramos, but since that time, I have not seen any paper which says that, which does that. Maybe there is one, but it's in secret. And what use is a secret policy? What use is a secret decision other than to foment oppression, other than to create disadvantage to people who don't know? That is my problem with that kind of system. Now, we do not have that paper, and therefore we do not have a publicly defined, publicly accepted determination of what the national interest is. In this respect, we seem to be still in a stage where, or a situation where people, either the people simply allow other people to decide for them, which is dangerous for a democracy, or certain people have taken it upon themselves that they know more, they know better than everyone else, which is also a danger to democracy. That's why it's not a good thing that is what's happening. What is going on, therefore, is that we're not able to integrate or harmonize local interests with the so-called national interests, with the so-called international interests. Prime example, of course, is that bill, if it's passed, you basically have made a decision to establish certain priorities for the uses of certain waters. Question, did you ask what the people of the LGU, which is the LGUs of Mindoro, the LGUs of Mindanao, did you ask them what they thought about that? Is it okay that whenever there's a foreign vessel, they just get out of the way? Is it okay for them? Is it okay that they're fishing here, their piles, for example, you have to take them out of the way because you have to give way to these foreign vessels? You have to ask them that. Is it okay for them to have all these foreign vessels passing through their waters without anyone watching, without the Coast Guard, without the Navy, so that whenever there's an incident, they don't know where to go to, or nobody knows what's going on? These are questions that need to be discussed before you even consider the kind of a major bill. The problem seems to be that our diplomacy, the way we relate to international community, is a bit more like a 19th century diplomacy, which is where a lot of it is conducted in secret, effectively conducted in secret, or a lot of decisions are made to the exclusion of the wider public. Now, true, there are some issues that probably would benefit, would be better made, that are better made by only a few people. But there's something as massive, as important as the national interest is affected. Don't you think that people have a right to know to somehow provide some input? That is something that we need to consider because we seem to be moving very, very fast on certain issues without the adequate consultation. And what happens is basically that all these silenced and ignored voices, their interests are being subordinated to others without their consent, without their knowledge. And I'm pretty sure that most people here will know, will probably think that there are many other instances where that has taken place. It's not just this one. It's been maybe it's a story of Philippines times. But are we going to keep allowing that to happen? It's a problem with democracy, really, especially democracy in the modern world, where you have all these communications available, where in an open society like the Philippines, things always get known, no matter how how much you try to keep it secret, they always turn out. How do we now position, say, for example, diplomatic policies and decisions that affect the international community and us? How do we position our people with respect to that? Some literature indicates, has been talking about what is called public diplomacy, where the diplomat's job is now no longer limited to just talking to the other country, but also talking to his home state, his home constituency. And that is something we probably need to really look at. If you remember Ambassador Kearney of the United States, I think that she did a very good job in public diplomacy because she was actually interacting on a much more basic level, much more down-to-earth level with Filipino people, not just the Philippine government. That is something we need to consider. But that is only one aspect of it. In making decisions, how does the public, what is the role that is played by the public in citizenry in this? Especially when their interests are directly affected. That is something I think needs to be some thought. Next please. Next slide. So I would really want to end this talk with certain questions in the call. No? First of all, well, what is the role of our people, which I already said. Second question we need to really answer is what are our key interests as a nation? First, to the exclusion of everyone else. Because after all, if you want to decide national interest, you're supposed to decide it yourself first. Yourself first. Don't ask other people what your interests are. How are such interests to be protected against regional and local forces? Because we have to accept it that we have these international conventions, we've already committed to them. They're coming, they're inevitable. And if we don't address them, we'll actually just be waiving everything else because whatever we do will be ineffective. So we need to actually step up to the plate. We have been given a problem, we have been given a situation. What are we going to do about it? And lastly, how is that protection going to be manifested? Certainly, in my view, despite the fact that I'm a lawyer and that I have a full doctorate in laws, I don't think, and I do not believe that law is the answer. I mean, just go down to EDSA. You already know what happens when you have laws which are not implementable, which are not monitored, which are not enforceable. Billboards. Despite the fact that we've had those laws against those billboards since the 1970s, but what happened? Now all of a sudden the MMDA is taking down billboards because they violated the law. Why? Where were you? Where were the people? What are the owners doing? What were these billboard builders thinking when they did that? Law is a limited tool. Without enforcement, without the infrastructure to actually implement them. That's very clear. And yet that seems to be what we have been doing lately. And that's why I really look at this kind of forum, this opportunity, as a very good chance to try to get this discussion going. And that's why I thank you for coming here, thank you for listening, and hopefully this will allow us as a people to be more be inquisitive, be more curious about what's going on around us, especially on issues such as this. What are our views on it? And what really should we do about it? Okay. So, thank you very much.
Thank you very much, Jay, Dr. Jay, for a very provocative presentation. I wish that Professor Rico, that all our political science 14 professors are here so they can echo the many, many provocative questions that Jay had identified for us. Now, I'll change the sequence of the discussants a little bit because I want Jay's challenge to be answered immediately by the Executive Director of the Center for International Law, Attorney Romel Bagares, who appeared, is it correct, with Harry Roque, another student of mine, as a counsel in a case filed before the Supreme Court questioning the constitutionality of the new baselines law.